Hi, everyone. So before we start, a few ground rules to set. First is in regards to time. Speakers are expected to complete their speeches before 7:15. Anything that is spoken after that will be completely disregarded as the part of the speech. And I encourage my panelists to do the same as well. Regarding the POIs, because the room setup is in person, sometimes it can be difficult to know which team is asking the POI. So the speaker who accepts the POI, please just indicate which team asks the POI. And also the one who asks the POIs, please be as close to the microphone as possible so that we can adequately credit that. Um, yeah, my name is Srizan. I go by he, him pronouns. I'd like to ask my panelists to introduce themselves in the order that it appears in the draw.
Yep, so Jackie, he, they pronouns.
Hello, my name is Marco. I don't have any preferred gender pronouns.
All right, so everything is in order. So I call upon the Prime Minister to present the case here.
All right, can everyone hear me? Thank you.
Oh, yes, you're audible.
Fantastic. Before I start, MacArthur FC, good luck in the semi-finals today. I'm missing the semi-final for this debate, so judges, please consider that. I'm actually going to start my speech now, though. Maybe you can drive me there. All right, sorry to everyone not in the room. I don't think it's controversial to say that corporations are the absolute scum of the earth. They rob from us, they tear down our trees, they pollute our waters, they destroy our workers' rights, and they actively donate against the interests of the Australian Labor Party. And those things, I think, make it only fair that we put upon these corporations rules in their governing bodies that ensure they have to actually act in ways that are positive for the community, that enshrines into legal rights in their constitution. They have to give back for the harms that they incur upon the community by basically existing. In terms of setup today then, obviously the model of the topic and the info slide and what it says will all apply in terms of who and what those sort of things are and what groups are considered, and is likely to be quite rigid in the application of how it works. The second thing I think is what they don't set up by terms of large. I'm not an economics student, but I'm pretty sure the definition of what makes a large company, that would likely be the definition that applies to which corporations this affects. As they get nearer to that size, someone from some regulatory body would tap them on the shoulder and say, hey, you're getting near there, time to start getting ready for this. Thirdly, we'd say in terms of breaching those things, when they breach the obligation of those groups, we would posit that it is those that are affected by that breach that could sue them. But in instances where it is like the environment, there's not like a person, like environmental action groups or groups like that would be able to sue on behalf of the environment to recoup the damages occurring, or things like governments as well. The last thing I'd note here is that like when we sort of, you're still as a company able to like prioritize certain issues or concerns or values of the corporation, but you just will not be able to say that one stakeholder matters more than the other. I think a good example to kind of illustrate what we mean here is that obviously a company wants to make as much money as it can for its shareholders, but to make things more environmentally sustainable, that would increase the costs. That would be okay in our debate to this side to like engage in more expensive things to protect the environment and maybe reduce the amount of profits the shareholders are making, because you are still meeting your obligation to provide money back to the shareholders. You're just not maxing that out at the expense of someone else's potential benefit, that being the environment. I'll take it now. Yeah.
Do you think that a mining company that wants to reduce its emissions is legitimate when it fires everyone that works on the oil well?
That was from CEO, and I think yes, because I think unfortunately the reality is that people are going to have to lose jobs in terms of the environmental revolution. I think the benefit of an oil company sacking all those workers is they're going to go back to a country and demand some action from governments, and that action would likely be some kind of program to retrain them or to provide them some kind of support if they cannot be retrained into other work. I think as much as it pains me to say, it is okay to sacrifice some workers in the short term in order to achieve longer environmental change, and this is a policy that forces companies to take climate change seriously, then we're proud to support that on opening government. And yes, Chris, we're actually proud. So in terms of the status quo and why that is so bad and cannot be fixed by any other means, the first thing to note here is there is an existing obligation for corporations to some stakeholders. That is primarily obviously safety and legal shit, but primarily for this debate, a fiduciary obligation to make money for its shareholders and to maximize the amount of profits it makes. Sometimes that is tapered by marketing of corporate social responsibility. Sometimes that is tapered by other laws, but primarily and overwhelmingly it is to make as fucking much money as they can at all times. And the problem here is that is a cripplingly poor incentive structure when they are faced with opposition to how much money they can make, and it forces corporations to make choices that compromise the quality of the environment, that compromise the communities they operate in search of that giant profit. Why is that unable to be changed in the status quo? Firstly, lots of people, lots of consumers don't actually give a shit about the harms that corporations make so long as they get their cheap products. They don't care about the sweet shops. They don't care about the Amazon. They don't care about the oil concerns. Secondly, in cases where they do care, there are limited alternatives when it comes to large companies because they're all likely engaging in the same sorts of damaging behavior somewhere in the world. So it's probably hard to be an ethical consumer. And even if there are ethical alternatives, it is likely to be more expensive because they are not taking the cost-saving measures of bulldozing the forest rather than going around it. So there's no capacity for you to really compete with them or make suitable amounts of profit going forward. So you really are stuck with no choice. But additionally, beyond the consumer mechanisms, there's also significant problems with the way in which government regulatory bodies operate, corporate capture and buyout our politicians. It means laws are weak and other things that prevent a systematic change. But also there's a first mover disadvantage for a lot of companies in making steps to protect them, to protect communities, or care about other stakeholders in a meaningful sense, because that does cost them money in ways it does not cost their competitors money. And given the likely short-term incentives corporations make as much money as they can before they get promoted or move out or retire or buy another yacht, it means you're stuck in a worse cycle. That's all important then because businesses can run rampant. They can destroy the environment without consequence. They can beat up the local communities they exist in. They can destroy our heritage and no one will care and they can keep going. That is why the status quo is fucked and cannot be fixed. What does our model actually do then to solve that? By making corporations B Corps, or all of them B Corps, and I learned in prep, it wasn't like B, like the B movie, which is my first thought, but actually another thing. So what you do by making them B corporations is that it equalizes the playing field by applying a set of restrictions and guidelines to all large corporations instantly and equally. That means no corporation is disadvantaged by taking the steps that are required to protect the other stakeholders, and that overcomes any issues of competitiveness, any issues of corporate capture, or any issues of countries having a race to the bottom to achieve the best tax haven status, the best the least workers' rights as possible in order to do this. But second thing, I think it forces the businesses to adhere to these restrictions because it changes the profit incentive now. Because if you get sued because you've breached an article of your own constitution, that is going to cost you more than you would make in profit. So it changes the risk calculus in such a way that corporations don't want to do. I think that is particularly important for those corporations. And even if it is still difficult to sue corporations, which obviously we can see that it would be, it is still far easier when there is a clear breach of their own governing constitution that applies to all of them than what it is at the moment when you're trying to apply vague laws or civil suits or things like that. What then are the benefits that flow from this? The first one is it's easier to seek redress now because individuals and groups can directly sue for a breach of a clearly written aspect of the constitution. There are two massive impacts here. The first one is the environment, and that does not understate the level of impact the environmental cause has in this debate. Climate change is destroying the earth. We will all be dead in 50 years. There will be no ANU Spring 2061 if we continue on the current path. And it is corporations that are continuing to do that by the pollution they engage in and the manufacturing and the way they operate. We can now have environmental groups sue these corporations. We can say that your activities here are in clear breach of your own obligations to the shareholders of this environment. You have to build things better. You have to do things differently or you will face massive penalties. And they can probably point to some arc of justice moving slowly in favor of the environment, but it is not moving quickly enough. And we need something more strict and more stringent than this. And it would only take one or two companies being sued and the rest would quickly catch up because they do not want to engage the same wrath that would occur. The second thing is obviously makes it far easier to enforce labor laws because unions and other groups can act collectively to sue these corporations and pool their funds and resources in order to identify how they clearly breach their obligations. The second benefit this incurs is you're more likely to see genuine, meaningful change. None of this rainbow bullshit that companies put out during Pride Month and then never act on. No more of this bullshit where they engage with local communities but then still bulldoze their heritage buildings to build apartment complexes. Now you actually have to stand up to the meaningful change you talk about, and that forces companies to adhere to the values they extol in their annual reports and their shitty marketing campaigns. And I know, I think it is important that corporations are actually held to account for the values they try to adhere to. And lastly, obviously, a far broader consideration of more stakeholders. Otherwise, we will not get a voice at the table because they're disempowered. But now they can say, here's your constitution, that's me, give me a voice at this table, and that empowers it. At the end of this debate, corporations are bad, we make them better, we propose.
I would like to thank that speaker for this speech, inviting leader of opposition. Here.
The opposition's model comprises the single biggest instance of corporate regulation in recent memory. It involves a massive restructuring of companies and forcing them to adopt a model which already exists and which they have actively rejected. It's in that context that clearly the opposition bench has the impetus and the ability and the fiat to provide an alternative as a means for dealing with the corporate problem. We propose three things. Firstly, regulating things like corporate capture and the influence of corporations over politics, opening the door to further lawmaking. And importantly we only need the political capital to pass those initial regulations. We say after that, the innate political capital in the people to protect their interests is more likely to manifest organically in the form of democratic policies. Secondly, passing basic regulations like the Dodd-Frank laws and other environmental protections to mitigate some of the harms that opening government talks about. And thirdly, empowering existing groups responsible for regulating corporations, for instance, labor tribunals, class action, environmental movements, and government watchdogs. These actors all have a far greater ability to actually fight corporations and their resources than the disparate set of literally just average, ordinary people who are unified by nothing other than the title of stakeholder. So, two arguments from opening opposition. Firstly, why the opposition's model or the government's model is ineffective at solving the problem of corporate misbehavior and why our alternative is preferable. And secondly, an argument about economic shock. Firstly, why is the opposition's model or the government's model ineffective? There are four reasons why. The first one is that the actual policy of putting in B corporation clauses is twistable by corporations in a way which is hard to blanket rule out and hard to stop in every circumstance. That's to say, they have the power to define the terms which are relevant to B corporation clauses. They have the ability to provide competing provisions within their bylaws. And given that that's the enforcement mechanism here, the bylaws, something corporations have direct control over, it's unclear exactly how many of the benefits of saving the world that open government can claim. Secondly, there's an asymmetry of resources. The enforcement mechanism for the balancing of stakeholders is the courts. And we say that the corporation and the shareholders and certain stakeholders have a massive advantage over the little guy who open government wants to defend. The labor unions, the climate activists have nothing in comparison or in terms of resources compared to the groups that open government wants to go after. The corporate interests, the shareholders, the people who are making the money. Right. Thirdly, there's a problem with paralysis in corporate decision-making, which is to say B corporation clauses are inherently a little bit vague about whether or not you're allowed to prioritize one stakeholder over another. As pointed out in a POI, sometimes you have to prioritize one to protect the other, or you have to deprioritize one in order to protect the other at all. And it's that sort of conundrum which corporations force B company clauses to be about. Because again, they have the power to set the terms of what is occurring, and they have the power to ensure that the most biting types of regulations and the most incisive forms of corporate control and reining them in are unlikely to happen because they necessarily require a trade-off of interest to some degree. Finally, we think there's the completely plausible situation of corporate workarounds. Stuff like basing your headquarters in different countries to change the stakeholder which is relevant to you, filing certain different corporate actions or new offices in different jurisdictions in order to tangle up and confound the regulators and the stakeholders. We think a watchdog would be far more able to track those things, given that it's their job to, as opposed to stakeholders who are essentially ordinary people now with a title. By contrast, why do we think our model is far better? But first, sure. Great, dude. You sure?
what makes your laws and regulations any less twistable?
Yeah. So that's the next part of well, yeah, good question. Why are they less twistable? Four things to say here, actually. The first one is that often adequate protections or protections which are growing exist at the moment in the form of statutory regulations. That's things like the environmental class action lawsuits, which Rob says aren't going too well at the moment, but are actually gaining steam. And recently in Australia, we established the right to be able to sue the government for not doing enough to protect the environment. It's stuff like using local council zoning to protect your area. It's stuff like suppliers having enforceable contracts against large corporations, allowing them to protect their interests to some degree. The question is, why then, what harm then does implementing this model create? It's the harm of backslide, right? You lose the impetus to keep these regulations in place. And in particular, you use the impetus to fund the regulators who make sure that those regulations actually take place. It empowers a very particular type of conservative rhetoric. The conservative rhetoric which says the tools exist for people to pursue their own interests. Let's offer them the freedom. Let's offer them the liberty to use these forums for negotiation to arrive at consensual agreements. It writes itself. I literally didn't have to write it down. It's the exact type of thing that conservative media will say. It's also, this is the exact type of model that the media latches onto and which will occupy a huge amount of the media landscape. It's to say that it's a very complex type of policy which people aren't familiar with. Negotiations between the various stakeholders are ongoing. And it's the type of thing that the AFR would be absolutely, salivating to cover constantly to the sacrifice of covering the actual problems which exist with corporations. Finally, compare, even if you don't believe that material about backslide, we have a fiat as established to push further regulations, which is a benefit. So compare the difficulty as a stakeholder pushing your interests in the court against other stakeholders or this corporation to the way our regulations get enforced. The first difference is that regulations have a statutory basis as opposed to a basis arising out of complex negotiations between stakeholders who, as we established, don't have an equal ability to bar out and negotiate for their interests. Meaning you're far more likely to get success under our side of the house where the regulation exists, as opposed to a situation where no basis for the negotiation or for the lawsuit occurs in a concrete way. Secondly, breaches of the law are viewed by the public as being far more serious or far more grave in general than if a negotiation between consenting groups of people goes awry, which has two outcomes. It firstly means that you're more likely to get pro bono legal assistance if you need to, as a small grassroots environmental collective, push a lawsuit, because it's the type of thing where a regulation has been breached and attracts a lot of public attention, as opposed to a situation where just, you didn't bring your A game to the negotiation table. The second outcome is that where our regulations fail, they're more likely to be adapted under our side of the house, because people are angry when corporations are skirting around the law and the people's will, but they're less angry when corporations are just playing the people who consensually up stakeholders in their agreements. Finally, let's compare the actor who pursues our regulations as opposed to the actor who negotiates under their side of the house. I think it requires a lot of work to explain how labor unions, who are basically just groups of people who elect each other, or environmental collectives, will suddenly be able to become the primary enforcer of these types of negotiations. It's out of the house, side of the house that makes it a watchdog. Rob already does most of the impacting about why this is bad, but clearly we do it better. That's the impacting for us as well. Finally, let's talk about economic shocks. Why do we think, just even putting all this aside, there's just an extra harm to their side? 3 reasons. Firstly, shareholders lose the guarantee of the primacy of return on their investment. Secondly, there's uncertainty with respect to the future of investment profitability, because it's much harder to predict exactly how negotiations turn out. And importantly, investors tend to operate more of fear than rational practice, because they want to protect what they have more than and they're more willing to sacrifice a little bit of additional profit. So this looks like mass divestment from stock markets. It looks like even further panics caused by that. Stuff like runs on the banks and shortages of consumer goods. And the impact is substantial. It's a large concrete harm. It's pension funds, it's super going away. It's a chilling effect on future investment. And by contrast, regulations tend to only target one industry at a time. They tend to occur more over time, and they tend to be more predictable in what they will lead to happen. For those reasons, vote opening opposition.
I would like to thank that speaker for the speech. To continue the case for OG inviting DPM. Here. Also, just to clarify, the previous POI was from OG.
What was the
POI
previous
that was
closing?
Opening.
No, she's asking Rob.
Oh, yes, sorry.
Yes.
all right.
Are you ready for me to start?
Yes, whenever you're ready.
The problem with the opposition bench in this debate today is they have completely ignored a major factor and stakeholder in this debate, and that is manufacturers and the developing world, who under their regulations cannot be targeted and cannot be helped with the numerous issues that they are facing from exploitation from large corporations from the Western world. Before I get into breaking down opposition's ideas and what they presented and why their regulations will not be effective and ultimately ours are more effective, I'm going to be focusing on this material of the importance of adapting B Corps to manufacturers in the developing world and why this is one of the most influential points in this debate. So firstly, why do we think it's particularly imperative that we enforce something like B corporations instead of imposing regulating corporate capture, environmental policy and things like that? And that is because those sorts of laws that have been presented by opposition can only be implemented on a country by country basis. And that does not help countries like, for example, developing countries who are being exploited by large corporations from other countries who do not have the ability to pass these laws. We think that they don't have the ability to pass these laws for two major reasons. The first one is that they don't have the necessarily financial capital to enforce these, because the corporations will simply just move elsewhere to another country that doesn't have, other regulations about treatment of workers, about particular pay and things like that. And so because they cannot risk losing these corporations in the region altogether, they don't have the ability to enforce, country laws on their own. We also don't think that they necessarily have the political capital or influence to force large companies from Western countries to do this, and they'll simply move elsewhere. We think that something like B Corps are in a better position to do this because of the idea that it is a basis blanket that has to be implemented everywhere. We think that the idea of implementing things on a country basis and having regulations that differ depending on where you are doesn't necessarily work for the international nature of most corporations, and also does not help these countries who are not able to implement things. Why is this necessary to implement now, as opposed to waiting for what opposition has talked about, where we're getting gaining steam and slowly growing? We see that this is necessary now because of judgments like the US Supreme Court made earlier today, where they said that chocolate companies such as Cadbury and Hershey don't have to have any responsibility over slavery or illegal child labor that is happening on cocoa farms in developing countries. It is systems like that that are currently happening in the status quo that mean that we need things like B Corps. Despite the fact that these companies have, pledged to do this to improve their conditions, despite the fact that they have told shareholders and the public that they will put systems in place and yet continue to fail to do so, we are not seeing any change in these areas. And we think that opening opposition has completely ignored the stakeholders of those countries in this case. So how is introducing B Corps going to have better impacts then for manufacturing companies, for manufacture in the developing world? We think it has twofold impacts. Firstly, it introduces better manufacturing processes in terms of improving human rights, enforcing things like better pay, working hours, less exploitation of child labor, all of those sorts of things. And we also think, secondly, it helps stop the exploitation of governments, land interests, and just developing interests as a whole that are often steamrolled and ignored by major corporations internationally who don't think that these countries have the ability to fight back. And even if we don't manage to solve all of the problems of child labor and slavery in developing countries from something like this, we think this creates a much bigger push than just waiting for social change to happen with companies that are driven by profit anyway, and so have no incentive to enforce these things. We think it creates a massive push for the welfare and workers' rights and for the treatment of developing countries that are currently being denied. And we also think that it gives a more direct revenue to pursue accountability and redress than in the current system, where if you want to fight against a large corporation, you have to do so in a very roundabout and tricky way. And so therefore, we think that this is an incredibly important point in this debate, and opening opposition has completely failed to respond to it. Yeah.
Your model also suffers from some jurisdictional confoundment, which call would you put the student, et cetera, et cetera. Is a watchdog or local labour union more likely to be able to manage that problem?
We think it wouldn't necessarily be like a system where it's like, you know, one watchdog or one labour union has to hold the responsibility for managing all of these issues. The way that B Corps currently is they have a system of overlapping watchdogs of regulatory bodies that work together internationally to hold these countries to account. And so we think that this is going to be more effective because when you try and get countries to work together on these issues, they are not motivated by the same push for welfare in the same way that, you know, labour regulatory groups whose entire purpose is to do that are. Countries are limited by like political issues, by alliances and things like this. And so we think that they are less effective, you know, talking about a framework like you have suggested. So then moving on quickly to why opening opposition's, you know, regulatory framework and the ideas presented on their side of the house are not going to be effective. So one of the major issues is in their idea of like regulating corporate capture and passing basic environmental policy and all of these sorts of things, is that it's not fucking fast enough. I'm sorry, we're sick and we're tired of waiting for large corporations to grow the fuck up and start doing something about all of the human rights and the environmental rights that they're exploiting. And we don't think that waiting for, or, you know, passing basic environmental policy is going to have any of the impact that we need to start seeing. Waiting for, you know, just because things are, you know, gaining steam does not mean that we are going to go anywhere fast enough, and does not mean that we are going to see the trajectory of change that we need to see in order to fix these huge problems that have been implemented by corporations in the first place. So we think like that's the first major issue. We think the second major issue is that they've tried to imply that, like, you know, laws that are based in statute, first of all, have like a statutory basis, which makes them more influential, and they're also like less twistable to be defined by corporations. So firstly, on this idea of the like less twistable, and you know that corporations will just have the ability to, like, you know, counter things in their bylaws and all of this sort of stuff. Well, first of all, that's not any different to how companies can currently do it in their constitution. And even if you're enforcing like basic environmental policy or regulating a couple of different things there, then you still give open the opportunity for corporations to modify their constitution or their bylaws to get around particular things. And so we don't really think that that is a harm that is unique in either situation. And secondly, on this idea of like regulations have a statutory basis, which makes it a more even negotiation. We think that, first of all, B Corps still have a basis to start off negotiations, which is like the rules that are presented in the motion slide. That's the ultimate basis where they have to start. And that jumping off point, because it starts as a more equal, broad terminology, being like all stakeholders have to be considered without prioritization, actually gives a better jumping off point for smaller groups of stakeholders to influence and to share their rights, rather than just having, you know, the situation where like the statutory laws are obviously going to favor, you know, bigger companies and stuff who have more influence in the political sphere, or that just like, you know, gain more money economically and so are benefited in that sense. And we also think that like the idea that statutory regulations can be adapted more easily is not accurate. First of all, we've seen that governments frequently get like roadblocked by political roadblocks and things of that nature. And we also think that trying to implement laws across an international basis implemented by, you know, governments is not necessarily particularly effective and can also be slowed down by these political ties. And so therefore that reason, we do not think that OO's alternative does anything to achieve the outcomes that we need to at the time that we need to, and therefore we are very proud to go. Thank you.
I would like to thank that speaker for this speech, reminding the speakers to please be within the time limit. In order to complete the case for opening up, I invite the Deputy Leader of Opposition. Also, the last POI was from opening up.
Last POI was from opening up, yeah. POI's in the chat, that's all right. Just kidding. What to get through is let's go fast. Let's start with opening government and their model. My observation is that this is quite vague and it's still a bit unclear what it stands for. I think it has to be one of two things. The first is the thing Rob actually says, which is that you can prioritize two things over other things, and you can POI me later if you want to clarify this further. The difficulty with that is you never, if you're Rio Tinto, ever have to not open a mine, because you can say this is good for workers, this is good for suppliers, and this is good for shareholders. So you get no environmental change because you can always cobble together a few people who are the people that you're helping. Although the other thing that it could be, which I think the motion is intended to be based on the info slide, is you can never prioritize someone aggressively or deprioritize someone aggressively. But that is worse because then you never open a mine. It means that Uganda never gets access to its natural resources. It means that those companies actually implode. So pick your poison, they're both fucked. Let's then talk about the developing world. First thing to say here is that this is a particularly good basis for us because they often need to actively deprioritize the environment in order to industrialize. And now they can no longer do so because you literally cannot get those minerals out of the earth. The second thing to say is that their enforceability mechanisms are particularly weak here. First, they are correct that there is an incentive for governments to induce these companies to not leave because they're so key to their profitability. Unfortunately, that works against them because it means that the courts are particularly amenable to them. It means the way the legislation is structured is particularly amenable to them. They're least likely to enforce it. Second, they have the least, like the greatest asymmetry of legal recourse because like workers and a workers union probably doesn't exist in a lot of these underdeveloped countries. And even if they do exist, they don't have the legal resources to go to court and battle Rio Tinto. This was silly. The third thing to say is you need constitutional literacy in order to do this in the first place. You need to pass the constitution and understand it. The fifth thing to say is that like in the developing world, we would just legislate directly via our counter model. So that responds to that in a series of ways. Our counter model then is basically untouched. We're just going to continue. We tell you a series of ways in which we can make these things better. Right. Why then? No, is ours better in a series of ways. The first thing to say is that we actually hit the core issue, which is stuff like corporate capture, which is what Rob talks about. You guys don't fix corporate capture at all. There is no mechanism for it because doing corporate capture is good for shareholders. It's good for your suppliers. It's good for you. And it's not something that's very scrutable. It's hard to know as an environmental activist that corporate capture is even going on. But secondly, we tell you that there's centralized authority and resources. Their mechanism is contingent upon awareness. Greenpeace cannot know every instance of environmental damage that occurs at a time. The only response we get is to say, well, you can twist the Constitution in your world as well. But ours isn't about the Constitution. Ours is about statute. It is hard codified. You let people write their own rule book. That is far, far worse. So no, it was, and note it's also concessionary, where they're like, well, yeah, it is bad, but also this. So let's then talk about why this is ineffective. 12 reasons. First, it is easy to twist the logic because you can just say you're prioritizing 2 over 1. You can say, look, we're helping these 2 people. Who cares if we're not helping that person as much? Second, as I mentioned before, there's an asymmetry of legal resources. And though Dan already tells you that there's a huge legal staff comparative to these small special interest groups, but also know it's the fear of having to pay costs at all. If you're a small community group and you're like, we're going to sue Rio Tinto, and they give you the barrister bill for 250 fucking K at the end of the day, that means you never sue them in the first place. Third, and note you need to be comparative in this debate, because this is not a debate about whether or not that thing is good. It is about whether or not that is the best way to use these resources, which this team has not proven. Third reason, paralysis. Because sometimes if you don't stand for the thing we think they stand for, you literally cannot do anything. You get to the core of these businesses' profit model and they just implode because you cannot build a mine. And you're a fucking mining company. I've already impacted why that is absolutely terrible. Fourth, as we tell you, they draft their constitutions themselves. They have license to define. They have license to give exceptions. They have license to amend and specify where it actually occurs. Fourth, fifth, I don't remember, adequate existing safeguards, no numbers from now on. Look, you have environmental damage suits. The community can block active development where it is likely to occur. Suppliers have enforceable contracts. And our counter model would beef those measures up. So even if they're insufficient, they're going to be better in our world. Noting the sheer volume of capital that this team uses in open government, they literally say to the most powerful actors in the universe, we are going to restrict you in the most core possible way. We can do a lot of stuff on our side. So, no, the next thing to say is that court proceedings are ineffectual because they're often too late. Like you say, oh, damn, the BP oil spill happened. That was bad for my community. The oil spill has already happened, which means you don't stop those things. And often they are not direct products of the things you are describing. The next thing to say is that you give them an incentive to move offshore because it's harder to adduce evidence about the environment in that instance. The community doesn't have standing. So no one's going to sue them in Rwanda or Uganda or Botswana because they don't want them to leave. And the courts are the weakest and the asymmetry of legal resources is the strongest. The next reason is to say it's incredibly inscrutable, not only because you need to know the specific instance where things like corporate capture are not, but also because it requires specific knowledge of that constitution in the first place. The next thing to say is that there are existing profitability incentives to become more green already, because as we all know that that's the future, as Rob himself tells you. Note as well that often the bad corporate activities and corporate lobbying are in favor of shareholders. They're in favor of lobbies, and these are particularly the sort of inscrutable things that aren't available on the annual general meeting minutes. The last thing to say though is an absolute worst, they settle. and it is the exact fucking same. They gave them some money, you did nothing, they still did the oil spill, you don't fix anything at all. The only response we get is it's not fast enough. Well, our contention is yours does nothing, so it sure as heck is faster than yours. Second, this is just asserted. Third, it does, because now Rio Tinto doesn't have to pay $50,000 for blowing up a mine in the Northern Territory which destroyed 54 Indigenous artifacts. They have to pay $50 million. So we do fix that. Ollie.
Do you have a lot of fiat because you're fundamentally constraining these companies, or does this policy do nothing?
We have a lot of, yeah, we're constraining them, sure. But we're constraining them in ways that we think are far more palatable and which don't absolutely nuke them in all the ways we described. Sure. Okay, we then tell you about market crash. We tell you this occurs for a few reasons. Absolutely no response to this argument, so I'm not going to step through it too much. I'm going to add some new stuff in a moment. But note that this is an incredibly concrete harm. You get mass unemployment. You destroy a huge number of these businesses because shareholders now know, oh, not only like my rate of return at my agency has fundamentally dropped to an enormous amount. I'm no longer getting a dividend from this company, which means that you have a huge, huge scale financial crash, but it's also a chilling effect on investment into the long term. You're always less likely to invest in those corporations. And note that that's worse in the developing world because they are the nascent, larger companies that need the most development. The next thing we tell you is that has a chilling effect on expansion because now you have no desire to become large because you consistently want to balance and be just on the precipice because otherwise your shareholders are necessarily going to lose all of their agency. That means that we don't get the benefits of large corporations like economies of scale. We need companies like Pfizer, we need GlaxoSmithKline in order to be able to do things fast and efficiently. But note as well that all of their harms just shift because you only have power where they are sufficiently large. Finally, there is a harm to corporate finance. Because the status quo, you're required to prioritize the rights and interests of creditors, you necessarily shift that in a very pernicious way, which means now that's subservient to the community, etc., which means creditors are far less likely to fund businesses in the first place, which means that businesses, again, just get absolutely fucked far, far smaller. So this was a policy that didn't work at all, and those 12 reasons to obliterate the core mechanism of the government side until CG rebuts it, that's live. Ours did way, way, way better stuff. And, we did a lot of stuff.
I'd like to thank that speaker for their speech. This completes the opening half. To open from the closing, I invite the government member here.
The question to ask at the end of opening half is what is the actual obligation of companies under the B Corporation's constitutions? Because DLO and OO broadly give you a number of reasons why the judiciary and the statutory regime are ones which are likely to interpret things in favour of corporations rather than against their interests. So let's look at the words of those constitutions to consider stakeholder interests. And you will notice that the obligation there is to consider. It is an extraordinarily weak obligation. It is not one of substantive outcomes, but rather one of undergoing a formal process of due consideration of the interests of stakeholders within that reason. And so at that point, if you accept that companies do not want to go to court, even if they are likely to win big by settling with multi-million-dollar settlements, but instead that they wish to avoid those proceedings, the question to ask is, will they do what OO suggests, which is go offshore and try to bypass this new regulation in a way which will irreparably damage their reputations, or will they take the extraordinarily simple step of codifying formalizes processes of consultation and published reasons in order to ensure that those court decisions favor them at that moment? And that is the extremely simple extension that we will give you, which is that companies will uphold the obligations they hold. I'm actually just responding to OO's interpretation of the way the judiciary will interpret constitutions, but also the words of the motion. So 2 things I will do in this speech. The first thing I will do is resolve the opening half clash as to their powers of fiat, whilst also strawmanning the exact institutions that they rely upon. And secondly, I will give you the extension, which is the far more plausible version of the world and the way that it will actually be interpreted, given the number of mechanisms we heard from OO as to why OG's scope of benefits are unlikely to resolve. The first thing to do here is to resolve the opening half clash, and I'll be taking closing. And they obviously prioritize getting up over OG's analysis in order of their fiat power, and they probably do this by providing a number of counterfactuals. But the first thing to identify here is that they really give themselves a huge amount of fiat available, which in an extraordinarily asymmetric way. So for example, they say things like, oh, well, companies can go offshore. Well, duh, obviously they are more likely to go offshore where there is a domestic statute which reforms exclusively within the state itself. Note also that statutes generally can only enforce when you're incorporated within that state, so it's extremely easy to have business operations within that state while else also bypassing that statutory reform. Note also that the institutions they say that have political lobbying and corporate capture and the kinds of capital that means it's unlikely to be stringently enforced against them also apply to their world. The second thing to identify is that a huge amount of their mechanisms are not mutually exclusive. Watchdogs exist within our world. In fact, things like ASIC and APRA enforce the statutes which currently exist. All that we do is give them another thing to enforce. So to the extent the watchdogs are enforcing, it's preferable if they have more things that they can enforce. The second thing to identify is that statute is merely a codification of constitution. So like in the Corporations Act, Section 180, the director's duty is to enforce their constitution. If the constitution is this now, that is just codified within the statute. But again, all that has done is reinforce our benefit. The third thing then is, what are the unique contributions, which are largely things like corporate capture? Those laws are domestic, and it is preferable to do something through the judiciary than through statute for a number of reasons. Firstly, though they say you don't have standing, the way that these constitutions operate means that standing is far more vested in a way that is not confined to jurisdictions, unlike in their world where there is a clear jurisdictional basis of standing, which is enforceable only by the state or through a statute which is confined to the law itself. Secondly, statutes, for all the reasons they give you, that they're constrained by political donation, are constrained by applying to the lowest common denominator, are constrained by the fact that they're stagnant and revocable, are constrained by the fact that they're likely to be overturned. Those are less likely to give you change than the extremely easy impetus we give you, which is internal reform, which provides for consultation. So then, why is our tick-a-box solution of formalized codification preferable? The important thing to identify here is that the actual change that is happening here is a procedural element rather than a substantive one, which is why Ben and Jerry's did this in the first place, not because they wanted to massively cut their profits, but because it's actually quite easy to get a huge amount of reputational gain whilst also satisfying this. And obviously that's why corporations could make a number of different choices in the same situation where there are competing shareholders and not breach this constitution, as long as they can prove that they gave due consideration and that there was no active prioritization of a particular priority group. And the unfortunate corollary of this is obviously mitigating OG's benefits and also significantly mitigating any of OO's harms as to an economic shock, because it is not likely that corporations will massively lose profits. Instead, all they need to do is this tick a box thing of proving this consideration. And there are reasons why they are likely to implement this. Firstly, for the reasons that they're likely to want to uphold their reputations, they're likely to want to avoid corporate watchdog enforcement, they're likely to want to avoid litigation. It's extraordinarily easy to implement, and it is something that will comply with the policy as it stands. Why then is this step actually one that is a huge benefit? And these are things like formal processes of consultation and paper trails. 5 benefits here. Firstly, this is a formalized process of consultation which cannot happen in the status quo. Because note, the fiduciary duty that directors currently have to maximize shareholders' interests is not just that they need to maximize profit, it is that if they decide to take environmental steps, they are actively breaching their duty to shareholders in the status quo. And that is also a reason why statutory reform cannot get up over that, because that existing corporations law is something which prevents them from taking steps which are positive to the extent they interfere with stakeholder rights. And those stakeholders will enforce it because they have a monetary incentive not to. In our world, there is the capacity to have this consultation in the first instance. Closing, do you have one for me?
Yeah, so my understanding is that you're not in your opening. Do you think, broadly speaking, that like if you could demonstrate that you consulted, but then like obviously ignore the conclusion of the consultation, You can still sue.
Two things. Firstly, it's not enough. Our opening provided a series of benefits. We're mechanising the way the judiciary is likely to enforce these constitutions. Secondly, courts often impart a duty of reasonableness into the interpretation of constitutions. So, for example, if you provide reasons and it is clear that there is no reasonable way that you were not prioritising a certain group, it is likely that the courts will still be able to enforce that constitution, which is why they are likely to have formalised reasoning process. Here's why you're likely to get actually moderated corporate decisions, and this is mechanising the purpose. Firstly, that sometimes those consultations will be persuasive in ways that they're accompanying reasons. Secondly, because you recognise that there is likely to be an ambit of reasonableness, which requires you to actually be able to justify your decision. Thirdly, because at the least it provides for certainty and capacity. Third benefit, you're likely to get transparency and opacity in decision-making processes which are not currently available. There is enforceability, and a failure to take those steps is likely to evidence and inference that you have failed to take that due consideration, such that now there is published reasons. This accords with the scrutiny of corporate decision-making in a way that allows for enforcement and strengthens the regimes that we heard that OO supports, which currently exist in the status quo. And fourthly, it's likely a norm that is likely to trickle down to small companies because they will prepare themselves for the stage at which they become a large company, and because that norm and expectation and reputational ability is something that is likely to be placed within corporations. At the end of this speech, we provide the actual mechanism by which these constitutions provide the environment, perhaps not to the same scale as OIG, but certainly to a more plausible ability. And we prove that that is significantly better than the counterfactual that OO pretends they can claim.
I would like to thank the speaker for the speech. In order to extend from CEO, I invite the OP member here.
All right, starting in 3, 2, 1. Let's start by surveying the landscape of this debate, because I think it involves a mix of people who are too brave for their own good and people who are too timid for their own good. Because at opening government, I think they're a bit too brave, coming out and sort of doing their best impersonation of the Lorax and trying to just sort of like ban all deforestation. At opening opposition, they never spend that much time trying to deny that it's actually a bad idea. They're like, oh, why can't we do something else? Like, come on, oppose, please. At closing government, they spend a lot of time saying, oh, well, it's not that radical. Promise me. Like, trust me, it's not a knife. It's not a knife. I insist. And I can guarantee about 2 minutes of Ollie's speech is going to be talking about how his isn't a knife. At closing opposition, we have a very simple claim, which this is a really bad idea, because it ruins the economy in a number of ways. It jeopardizes regulation into the long term, and we don't require any fiat. Dude. We're all idiots. Okay, everyone, please stop laughing. I actually have to get through some content. On closing government, they talk about how, well, they're going to consult with people, and actually it doesn't involve that much. Consulting with who? Fucking squirrels? But also, the big claim is that this won't be that big of an infringement on companies' rights, which is, one, a knife, because, and here's why, because opening government says the reason companies are really bad right now, for instance, fucking over workers, etc., is because that is really profitable. So if it is the case they are to get any sort of openings benefits, they need to do something that's really serious, then it is a great infringement on the economic freedom of these companies. But second of all, if it actually was good for these companies, why aren't they doing it anyway? Yeah, because if it is the case that it does attract investors, if it is the case that it looks good, do it anyway. Cheers. So let's move on to the meat of this speech, which is 2 points of extension. First of all, it ruins the economy short term. Second of all, it ruins the economy long term. On the short term, opening opposition says basically what shareholders will do is they will notice that these regulations mean that the likely sum of dividends discounted for inflation, etc., is down. Therefore, they will take their shares out of the market, economy crashes. We're going to mechanize that a bit better. The first thing we notice is that investors are likely to succumb to a short-term panic, because it is worth noting the incredible amount of vagueness in these contracts, but also the not knowing exactly how it is that courts are going to regulate this. What this means is, I think it's like you just have to imagine that you do own shares, for instance, in an oil company, and this policy is announced, you're going to want to get out, but even if you think, well, it's not going to be that bad, you're going to know that everyone everyone else is thinking the same thing, at which point you want to be the first one to get out, at which point this does have ramifications throughout the rest of the economy. Second of all, this is definitely original, so Seamus, please don't get mad at this, is it basically makes certain industries illegal. Because, for instance, mining or oil, but also arms manufacturers like Boeing and Raytheon, I'm not sure who it is you're going to interview. Are you going to fly over to Yemen and consult people? I'm not really sure what's going on there. And we think in those cases, basically this policy, if it is to do anything at all on government bench, and if closing doesn't want to knife their opening, basically they are going to have to basically shut down incredibly large multi-billion-dollar corporations. And this is important because it's not just like, oh, we get the bad part of the economy, sort of cut that out and toss it in the bin. It's all linked to everything else. Because, for instance, navigation systems, a lot of technology, a lot of chemical engineering is so closely tied to that, and that's tied to other parts of the economy. Close webs of finance that mean that banks or pension funds have a huge amount of money invested in these. So it's the case that where you have certain parts collapse, that ramifies very quickly. There are domino effects. The impacts of this are twofold. The first is a likely recession. And note some important things about this. Like, recessions do kill people, but also recessions lead to more exploitation. Because if nothing is that particularly profitable, what you're going to have to do is exploit natural resources harder. But also it means that companies have way more leverage over workers if there's nowhere else that workers can go because unemployment has spiked. So if it is the case that they do care about workers, creating a recession is the exact opposite of that. Second of all, it poisons all future regulation, because even if this regulation does nothing, it creates an incredible amount of fear in investors, which ramifies through the economy. And what that means is that any sort of future regulation that will do anything for workers or the environment or anyone else is seen to be entirely antipodal to any economic interest. And what that means is we're currently going on a trajectory towards future regulation. We don't need any fiat for this, but doing this one regulation that will be disastrous will permanently poison the future of all regulation. And to the extent that opening government does care about regulation, we get that far better. On opening government, yeah.
If all those regulations are effective, then your analysis of stakeholder sad ... economic collapse still occurs on your side.
Yep.
So are you knifing your opening or undermining your own case?
No, okay, thanks for that question. I'll clarify. Basically, we say regulations that basically outlaw certain particular practices do not create fear in the way that vaguely worded contracts that no one knows how they're going to be enforced are. But also, we said that regulations aren't going to ban certain entire industries in the way that your interpretation of this topic mandates it. Moving on to the second part of the economy. First of all, we say there is an incredibly high cost to companies growing, such that they're not going to want to grow into the future. That is, there is a huge added cost from going from medium to large companies, assuming the model is actually effective. At opening opposition, they're like, oh, this is derivative. Like playing number wang doesn't count as actually claiming a point. What we say is, in economies, there are competition between medium-sized firms. And we think that if there are two competing medium-sized firms, anyone that expands to be large enough in order for these regulations to come into activation means that they necessarily become less competitive and they will be outcompeted. So that means that no one is ever going to expand, which means one, the economy ends up being far less efficient, but second of all, it makes government's model not work because no companies enter the area at which they are regulated. Second part of this point is there is a far lower incentive to invest now because you need a promise of huge future growth, such that, for instance, if you're investing in developing a new type of crop, or you're investing in developing, wind turbines, etc., you want a promise of having a large swath of the largest company in an industry. And if you know that there are huge costly effects on companies growing past a certain size, that means you can't justify venture capital to begin with. Third of all, it basically outlaws creative destruction, because to the extent that you have bad effects on like external actors, such as competitors, such as the rest of society and consumers, what that means is it basically outlaws the fundamental mechanism of capitalism working. This is important for a few reasons, because although opening government says, by God, I hate companies so much, we would note that one, companies employ people. That's pretty important. And we think having an efficient economy that employs people in the most efficient way, that actually provides goods for people, is important. Second of all, they sell products to people. So at the end of this speech, we say the government bench is caught on the horns of a dilemma. If this model is not effective, it still causes a crash and it poisons all future regulation. But if it is effective, then what it will do, it will eat the economy in the short term, in the medium term, in the long term, but also what it means is that they don't get any regulation because large corporations get outcompeted by mid-sized corporations that do the exact same thing, way worse, way less regulation than the comparative, and that's why closing opposition's ahead.
I would like to thank that speaker for their speech. In order to close out the government case, invite government whip.
Let us begin with closing opposition. They provide two contributions to this debate. The first is suggesting that our case is a knife, and the second is a knife. Let us deal with the first one. And I have 2 minutes on the clock, so this will end at 2 minutes and 14 seconds. However, I will not need that because opening government claim a series of benefits of this policy. Opening opposition make the astute observation that corporations can be sneaky buggers. And we suggest that when corporations are sneaky buggers, this is the most likely interpretation of how they will do that, and it still accrues the benefits that opening government suggests. That is the reason it is not a knife. It is simple debating. I would suggest Benjamin probably just rebut us on our own terms rather than that lazy piece of rebuttal. Let us now deal with their actual extension, because their actual extension is like the last 30 seconds of both of the opening opposition teams' speeches, because they are just like, this will ruin the economy. And they basically provide two mechanisms. The first is saying shareholders will get scared, and that is 100% derivative. There is literally no new analysis. But the problem is that remarkably, despite being derivative, it is also a knife, right? And that is for the reason that their claim is just that you will fuck up the economy, and anything that makes companies, like have to do nice things to others is bad because it fucked up the economy. But opening opposition are suggesting something that will more effectively stop companies from doing what they want to do. And the helpful piece of nuance that they provide in response to a POI is to suggest, oh, wait, no, the difference is this will make shareholders more scared because it is in fact more vague. So you don't know what's going to happen. I would say this certainty of the effectiveness of a policy in making sure that shareholders are not prioritized would certainly have the effect that they describe. So it is either a knife or derivative. It is fucking remarkable that they did both. The second contribution they make is actually brand new, and it's just saying it will make certain industries illegal. Now, I basically have two observations here. The first observation is this is enormously concessionary, because they are conceding that this policy will be so effective that some of the worst industries in the world will disappear overnight, right? And that is a very good thing. There are some industries that, if they cannot function without destroying the planet, destroying communities, should not exist. And if we get some harms along the way, like industries collapsing, short-term financial shocks, whatever, we're happy to swallow those. Which leads me to my second response, which is that they do not engage in any meaningful way. Because the impetus set up by this opening government team is that we are a world in crisis, a world captured by corporations that are destroying our planets and destroying our people. And their response is that, however, in the next 5 years, very wealthy people will lose some money, and that might trickle down and hurt poor people. What will hurt poor people more is having their countries swallowed up by the ocean. And that is what the government bench provides you. The easiest way to avoid the greatest scale of harm in this debate. So CO is certainly out of this debate. Let us now move on to the more sensible opposition team, opening opposition. And I use the term more sensible relatively, because they are, of course, not very sensible. Let us begin by assessing their counter model. No, boomed. Let us assess their counter model. Their counter model is threefold. They would regulate culture capture, they would do laws, and they would empower groups that make sure the laws happen. I have three observations about this. The first observation is that they claim that this requires the same fiat as what we would do, totally without any analysis. They're just like, what we do requires fiat, so we will do it too. But notably, what they do requires a lot more money. It requires all companies to adhere to them as opposed to just large companies. And it requires you to pass far, far, far more laws and empower far, far, far more industries. And what we are doing, which is one law that affects a few companies, and those few companies being affected would be audited by like one watchdog. So certainly they don't have the fiat to do everything they're suggesting. And the punchline, guys, don't get offended, is you do some of it, but certainly not the extent of we will fix everything all at once overnight that you suggest. My second observation is a debating fiat observation, which is that their fiat, as explained at the beginning of this leader of the opposition, is naturally tied to the fiat that we have, right? Because they suggest they are fundamentally reforming industries in the most powerful way possible. And they prove this by saying it will create great economic shocks. So surely we have a lot of fiat. But all of their material that explains why opening government's case will not be effective explains to you why their fiat would naturally be smaller. Because if this is not a large imposition on companies, if companies can just get out of it, then surely they don't have the fiat to then additionally just constrain companies in their exact way. So the rules of debating would constrain their effectiveness in this particular instance. And the third problem with their model is simply that even at its most effective, companies and corporations still have a legal obligation to their shareholders, which means that their shareholders legally always have to be prioritized. No matter what laws you put in place, no matter what obligations you put in place, there will always be a paramount obligation. So there is a natural cap on their effectiveness. So that explains why in the first instance, the comparative that is set up in this debate for you does not exist in a reasonable way as they would suggest. I'll take Daniel Yin.
Prime Minister talks about literally forcing the companies to fire people on oil rigs. DPM talks about restructuring the developing world. All you seem to suggest is that you're doing some consulting. So is it the former, and we do get a huge amount of fiat, or is it the latter, and you're knifing your own?
If you want to talk about contradictions, half of your case is saying that they're not effective, and the other half is saying that they're so effective you'll cause economic shocks. So, you know, like pot kettle, black glass houses, all that kind of stuff. But to direct it more effective, to respond more directly, is that, again, like, we are just suggesting, if you guys are right, this still has massive benefits. Like, that is just such a simple even if. It is totally absurd of you to go down that road. You really think that's going to happen? Really? All right, let's now. Oh, fuck. Now, let us deal with their case. And the first thing I want to deal with, because I think our extension pretty neatly explains why a lot of their mechanisms aren't effective or we get up over them, is to deal with their material about economic shocks. They essentially just have one claim, which is just that shareholders will lose certainty and therefore that, this will happen. Now, as I've already pointed out with respect to closing opposition, who just then repeat this material, this is enormously concessionary because either we cause a big change and this economic shock happens, in which case we're willing to swallow that benefit, or you buy all their other material that this doesn't cause a large change, in which case the economic shock material cannot carry in this debate. But the other thing that we would note is that, importantly, we prove to you on our side of the house why it is possible for this to happen in a stable, reasonable way that does not generate the kind of panic that they suggest. Notably, the vagueness of the policy that they describe is explained by Madeline to not be something that exists, and thereby the core mechanism behind this argument falls down. Let us now turn to the rest of their case, because the main observation I would make is just the enormous degree of symmetry, right? Like, their suggestion for why their model is better is that statutes are good and watchdogs are good. Well, we also enforce things through statutes, and we also enforce things through watchdogs. So there is a degree of symmetry there. And if you look at their material as to why our case is ineffective, the sum of it is simply that this model will not be perfect. It's the trivial observation that corporations are powerful and sometimes worm their way out of obligations, as opposed to explaining why this will collapse in and of itself. Certainly at the end of this debate, closing government is the team that explains to you why you actually get the benefits of corporations looking after the community and the environment. And we are the team that most clearly explains to you why the false comparative setup, necessarily something that must be engaged with by the government bench, is one that falls to the government bench. That is why we win this debate.
I would like to thank that speaker for the speech. In order to complete opposition case and this debate in general, I invite the op-whip here.
It's swinging on a chair in hard mode. I was trying to challenge myself there. Oh yeah, shit, dude. I almost fell over while teaching a class. I was just stumbling around so much, and I had to grab the podium. One kid noticed, and he lost respect for that. All right. Cool. This debate has had this very funny property where everybody is extraordinarily keen to talk about why, using very rarely arguments, more boutique interpretations of the rules of debating, other people's arguments aren't valid ones. And that, of course, trickled down into Ollie's whip speech, which used the expression "our extension" once, then didn't say it, right? Which, of course, indicates the fact that their extension is basically it's difficult to rebut because I don't know exactly what it is. It appears to be, but they're like, so what you need to do is you've got a form, and the form says did you ask 3 people, one of whom is vegetation, whether or not this is a good or bad idea? So novelly, I'm going to begin by describing our argument and describing which is novel because it is both an argument which is novel for this debate, and it is an argument that we make, which nobody else seems to be particularly keen to talk about, their own arguments. Firstly, so the main accusation that we get is that we are derivative. Now, I think a simple way to know that this is not true, because obviously it's an economics debate, and so opening opposition makes the important observation that, you should have an argument about the economy. But they take about 30 seconds to do it in each speech. And that means that they fail to do 4 things that Mark does. Firstly, They fail to perform analysis. They said the headers. For example, the word uncertainty certainly came up twice in the opening half, but they did not explain then how uncertainty would affect market investment. They just took it as given. That is a thing you would need to do in order for the average reasonable person to believe that uncertainty is going to occur. Secondly, they certainly did absolutely no work impacting this argument. As we know, arguments have two important components, mechanisms and impacts. And the second is equally important to the first. Mark provides the second. Thirdly, their arguments were profoundly unspecific. We're often taught when learning to debate that if we can apply arguments from other debates to this one, we need to identify the relationship between the argument and the motion. And yet, curiously, opening opposition did not do this. And fourthly, we properly distinguish the ways in which these arguments will operate from regulations. That is the nature of the extension. The other response that they say is that you will ban companies that are like the companies that will be made illegal by this are the bad ones. But that is actually probably not true, right? Oil companies are actually somewhat unlikely to be targeted by this because they're enmeshed in a complex set of relationships in which the trade-off between the communities in which they operate, the workers that they have, the stakeholders who they're obligations to, and the environment are zero sum, and people do genuinely stand to lose. The companies that are going to get owned by this, the companies that you want to start, yeah, or companies that are rapidly scaling up. And those are not necessarily bad, but there are a bunch of people for whom their entrance would be catastrophic, right? So that is why we thought that was a bad thing. That's literally Ollie's only other response to this. This argument has the important properties of being very important. It hurts a large number of people. It has the important property of being certain. It has the important property of not relying on crazy rules about fiat. And it has the important property of being properly made. So all we now need to do is really, I think, to be honest, all that I need to do in this whip speech is say the claims in the other teams and then do a funny face. And I think we go through it. So let's begin by doing that. So opening government's case is completely busted for two reasons. The first is that they never explain why really any of the reasons that regulation is difficult that they talk about would not apply to the things that they describe. And secondly, their comparative is the status quo, but insofar as obviously our opening has identified there is a degree of fairness in this debate, there will be some regulation. I think both of those problems are fairly self-evident, right? I'm not necessarily going to say that they're like dumpstered or anything like that, but you know, it's kind of hard to credit them with too much. Now, opening opposition does the weirdest thing. It was like phenomenologically unusual watching them make their case because they knew what needed to happen, right? They would go, okay, so here's a bunch of reasons that this isn't going to work, yeah? And then you would say, okay, so it's like the moment of truth. They would say, okay, and here's why it's not true on our side of the case. Then they would furrow their brow, speak incredibly fast and say nothing, right? Like they struggled extraordinarily. It was crazy. Like Seamus got up there and he had like 12 reasons, yeah? And each of those reasons was a louder cry for help, yeah? Like none of them were comparative. None of them. I mean, fuck, what were they? What did the sheet recommend them? Yeah, so he said firstly, you know, statute's good because it's written down or something. He said something about there being some conservative rhetoric. He said a bunch of other things too fast for a human to understand. You know, it was seriously the analysis and the paucity of it here was interesting. But the other thing that I think we should acknowledge about this, and we should acknowledge about the opening half in this debate, right? Yeah, I'll take you in a sec, right? Is that at the end of the day, obviously the biggest moving part in the success of any regulatory framework is the amount of fiat you're giving to it, yeah? The opening half is actually extraordinarily marginal. They're both imposing systems that are likely to be substantially constrained. Both of them are arguing at the absolute margins about which system will be more effective, which means even though they're talking about big imperatives, they've got truly extraordinarily little efficacy, even if you think they actually were making arguments. Yeah, Rob.
Mines are probably still open on both sides of the debate. If mine's open on our side, at least now they're forced to consider environmental impacts more, consider the community they interact with more than they are on your side. Is that not still some kind of a benefit? Thank you.
No, thank you, Rob. That was a baffling decision, mate. Because you've got the ace in the hole that you're closing totally knifed. And then the language choices that you made imply that you agree with them. That's like you standing there being like, wait, no, people think that I got knifed. No, I'm not owned. Fuck. It's just what a weird choice. You're gonna DCA world. So finally, let's talk about closing government. So closing government obviously wasn't enough. Ollie then took 30 words in an extraordinarily smarmy way to say, but it's literally different, right? They think you should check a box. These guys think that you should be able to sue a company that does pretty much anything wrong. Yeah, and Ollie, you can do a funny face all you want in your speech, mate, but at the end of the day, words have meaning, buddy. Arguments refer to concepts and realities that exist in material spaces. They're not purely a game of chess. But the other thing is that the benefits that they want are really, really small at that point, extraordinarily small. They're not as important as the economic harms. Because then they're just well, maybe sometimes a company will be persuaded. And it's if the CEO of Raytheon goes out and appreciates nature, yeah, and then the policy that you get out of that is just not worth completely ruining the global economy. You love to do the thing at the end of the speech where you're I'm so proud to propose. I have no idea what happened in this debate, but I think we have gone through.
I'd like to thank that speaker for this piece. This completes the debate for the round. Yeah, the announcement will be made later. So I think the Zoom account that is allocated for this room can leave, leaving the panelists to deliberate. Yeah, Mark Rotary.
Oh, did I miss you?